guys. Welcome to the Beaufort Digital Corridor, and thank you for joining us for today's Lunch and Learn. We're so excited to have Tim Johnson here. He's going to be talking about giving us an introduction to the art of IP. Before we get started, we have a couple of announcements. So, as you guys may have heard, we have our Run Forest Run coming up. It is our grandest fundraiser of the year. We'd love for you guys to sign up. We announced it last time, but also I want to mention this time that we do have the option to create teams when you sign up for Run Forest Run. So you can get like a group of your friends or your families together and run as a team. Awesome event. We hope you come out for it. We also have Tech Connect tomorrow night. Now, I know a lot of you have already been. Have you been, Tim?
No.
We would love to have you at Tech Connect. It's tomorrow, 5:30 p.m. It is a networking event for tech professionals, business professionals. There's a new place that's open in town called Windhorse at the Shed. We're going to be having it there. We're going to have wine tasting. It's going to be really fun. So if you guys come out for that. And also, I want to let you know, back to the Run Forest Run, just know early bird tickets for that do end on September 1st. So keep that in mind. You can check out all of our events and sign up for everything at beaufortdigital.com/events. And without further ado, here's Tim Johnson.
Thank you. Appreciate it. So I'm Tim Johnson. I'm one of the co-founders and CEO of Longship Legal, which is technically is a law firm. We call ourselves a legal service provider based here in Beaufort County, and I'm here in Hilton Head, and my co-founder is in McLean, Virginia, and we focus on business-oriented intellectual property law. And so I appreciate the BDC offered the chance to come help by giving a lunch and learn about what we do and focused in on intellectual property. And so that is what I'm going to talk to you all today about. The art of intellectual property is what I call it, and as the focus of the talk. And the reason I say that is because intellectual property in some aspects, when you're talking about like patents and trade secrets, often can have a sort of technical aspect to it. But when you look at what it does for your business, it's a much more artistic sort of how does this all work together idea of intellectual, meaning, not tangible assets that you have to deal with. And it doesn't always lend itself to perfect, I have one trademark that is worth $5 type analysis. And so it's a little more of an art and a feel of what you're doing. If you do it right, it can be amazing. We talk about it can be a booster rocket for your business. If you do it wrong, it can be a way where you spend a lot of money and afterwards go, what did I get out of that? Which we don't want anybody to have. And so Longship Legal was designed to provide a method by which people can actually, like working with their lawyers and know what they got out of working with their lawyers with an IP focus, because that's what I've been doing for the last 15 years is intellectual property law. And so I appreciate the chance to talk with you all today. So that's the introduction to kind of talk. This is what we're going to cover. I'm going to give you a little bit. I kind of went into it already, but we'll stop on a slide about what exactly Longship Legal is for a second. Then we're going to go through business. That's the direction I like to come at intellectual property. Kind of how I like to come at all of law, which is we are a service provider. If you think about legal, whether you're thinking about it of a lawsuit, hey, I got sued, hey, I want to sue somebody, whether you're thinking about it, I need a contract, whether you're thinking about it of I need intellectual property, as we're talking about here, the focus of that is how does it help your business, right? And as a service provider, when all your other services, whether you're thinking about HR, whether you're thinking about, I need to buy furniture for my business, whatever it is, it's how does that serve that business and how does it help you go from today to tomorrow and where you want to be? And so for us, that's how we come at it. Does whatever legal service you need make sense for your business? And that's what I'm going to try to give you the tools to think about intellectual property. How can it help my business? Will it help my business? What do I need to do? And so we'll start there. Then we'll go through kind of what IP is, intellectual property. If you hear me say IP, it's shortening intellectual property together. We'll talk about kind of what the value that can bring to you. We'll go through 4 of the major types of intellectual property that there are: trademarks, patents, copyrights, and trade secrets. There are a ton of others, but we're going to hit on those 4 because they're the most common and the most kind of directly value impacting that people will have, although there are others that can be even more valuable to specific businesses. And then I'll talk about how you can use IP to build value. And then we'll, at the end, we'll kind of give you a rubric, and that's what I want to get to as fast as possible. Talk about how you can think about whether there is a need for a legal wrapper around intellectual property in your business. And so that's the talk today. Before I jump into that, anybody have any foundational questions or things they want to know? Like, I don't know, is anybody in here a lawyer that, like those kind of questions? If not, I'll get started. All right. So I'm Tim. As I said, been doing this for about 15 years. Before I did that, I was in the Navy. I was a supply officer. Was never stationed here in Beaufort County, although I drove through it because I had friends who were up at Nuclear Power School in Charleston. I spent my time in Athens, Georgia, and then around the world doing that. Got married, had a kid, one kid. Now I have three, and decided this is fun, but maybe this isn't something I want to do for the rest of my life. And thought about going to law school, and so I started doing that. Was living in Washington, D.C. at the time, and fell into intellectual property law and really liked it. I have a control systems engineering background, and it was just kind of cool to be there and be like, oh, there's this thing that can marry up engineering and law and business and all this together. And took one class in it just to see if I liked it. Really loved it, and that's what I've been doing for the last 15 years. I used to work, I've lived here in Beaufort County for 10 years. Used to work remotely for a IP boutique outside of Washington, D.C. Was a partner there. Loved the people that were there. Didn't so much love the business and the way we approached it, and kind of had this nagging feeling we can do this differently. Wasn't able to do it as a partner in that group, so founded my own law firm last year with another gentleman, Dave, who's up in Washington, D.C., and we've been around for over a year. So if any of you have small businesses, you know how tough the first year can be. We've been there too, but we're here in year two, and so it's great to be able to talk to you all today and kind of go on that journey of explaining how IP can help you in your businesses and a little bit of what we do. As far as Longship Legal and what we do differently, I don't know that anybody will necessarily need it. I'm one of the rare lawyers in the world who will tell you you can actually succeed in your business without a shred of registered intellectual property. And so, but if you have any IP questions or things you want to call us, I'm local. My number in here is our kind of general number, but my cell phone's on the business card you all have. Feel free to call me. I'm glad to talk to anybody about anything. You will tell by the end of this I am a talker. But definitely if you have intellectual property questions or anything that you think might be there and is legal, feel free to call me. If you need a real estate closing, find somebody else in Beaufort County, right? But yeah, I'm glad to talk to you, friends, family, anybody, and kind of send people on the right way and tell them in reality, do you need something? Is it something that can help you? Although what I'm going to give you here, hopefully I'll let you kind of answer that questions for yourselves as you go through business life. So business, maybe I'm giving it away here. Like there's an academic definition of business up here on the slide. What does business mean to you all? Does anybody have kind of what they define when they say, hey, I'm in business or I'm a business? Or maybe let's just show of hands. How many folks here are business owners? All right. How many folks here are business operators but not owners? All right. And does anybody have a definition to themselves of what that means when they say business? That's all right. You don't have to. So a kind of academic definition right here is an entity could be anything, right? That could be a nonprofit, could be a for-profit entity, doesn't matter. Engaged in commercial, industrial, professional activities, right? Like the BDC here, maybe not a business in the roughest sense of somebody thinking like transacting, I'm selling a good for money, but is a business in the sense of doing things that, assist folks and create value for its stakeholders. So literally that definition is big enough to encompass charities all the way to McDonald's and everything in between. And intellectual property is something that can help things all the way from charities all the way to McDonald's and every business in between. It's just a question of what type of intellectual property could actually help you. And so we're going to talk about that next. And when I say help, I mean, how does it create value for you, right? And so when we think of businesses in general, right, I think everybody knows revenues, right? Like the money coming in when you're thinking of for-profit enterprise. Although even in a nonprofit world, like it might be foot traffic, the number of, you can think of it another way, maybe the amount of charity, outbound that we give. There's some type of cash flow, revenue, etc. There's assets, things the business owns, right? Could be things from a mailing list, something that kind of exists, to actual physical infrastructure and goods and furniture. And then there's a market advantage, right? And that gets into that little, sometimes, has anybody ever heard the term like, goodwill in a business value transaction, right? The market advantage is a big part of that, of how do you distinguish yourself? How do you do those things? And so when you're thinking of how do you value a business, those are three big, inputs that you're looking at. And so where does intellectual property fit, right? It's not perfectly up here in those kind of three major inputs. And so the way I like to think of intellectual property is all the things that are not tangible assets, right, that can fit into helping that business. When I say intellectual property, the one additional thing I put on that is a legal regime that recognizes it. And how to draw that distinction. If you've ever seen if you think of a contract, right? If folks have seen even a basic contract might say, I have an obligation to you, so you're going to pay me this amount of money, and I'm going to move this furniture from point A to point B. Is the two aspects of that contract, right? That agreement to do the thing as part of that contract is an intangible asset, right? Like you have the contract which memorializes it, but you've got this agreement between two human beings, two businesses, whatever, to do a thing that has not been done yet, and that's intangible. It's not the same as going to value, as you all should have a giveaway coaster, right? That's a thing, that's tangible. And so intellectual property is when we take something that's intangible, which there's a bunch of them in the law, and we wrap a legal regime around it that says we're going to treat that like it has the aspects of something tangible. So if we think of real estate, like if you own a piece of property, right, in the real property sense, that's tangible. You can go out and say, it's in Beaufort County, it runs this many meters, this many, yards in relation to this, GPS coordinates, whatever. We're giving a legal wrapper to things in intellectual property that are taking intangible assets and making them definable so that we can talk about them and transact. And the way we do that is through a set of systems that the governments around the world, but we're going to be talking today about the United States and the federal level of the United States specifically, have laid out those metes and bounds for you. And so when you meet those requirements, you can get a piece of intellectual property of whatever type, in our case, Congress has laid out in statute that you can have. And so I'm going to talk about the four major ones, but I've actually got a list here that is pretty amazing of stuff. We were talking about boats before it kicked off. Sorry for all the folks on the live stream or at home. You didn't hear that part of the conversation, but like hull designs is a separate set of intellectual property that's defined by Congress. We have the actual mask works, which if anybody's ever, if your phone and you think about silicon chip manufacturing, mask works discuss how the different things are laid out on the chips. That's a separate piece of intellectual property. Geographic indications of where things come from, and a newer one that is growing in popularity that the United States has not quite caught up with, but it looks like they might, is database rights. So all that data that all our devices are making, that we're all transacting online, specific rights and requirements and ways to say, I own this database or this data are coming to be. And so there's a lot of them. Domain names is another one that's there. I'm going to talk about the four major ones, but there are other things that pop up in the orbit of intellectual property. And so when I'm talking about intellectual property, and we'll learn about the four major ones, but all those kind of legal regimes, why do we care about it for our business, right? Does the intellectual property by itself make a sale for you? Not really, right? Does the intellectual property by itself make the water bottle hold an extra ounce of water or compete in that way? No, it doesn't. But when you look at the overall value of your business, of why you're in it, especially as a business owner, when you're thinking about where am I going with this business, the intellectual property has a chance to build value from the work that your employees, and the work you've done in the business in your brain, because it's intangible, to build a value that you can extract potentially later, right? And so it becomes something that, if you're thinking of different exits, and I've got a few different kind of numbers here of ways to think about it that can impact. So if you're a new business and you're trying to raise money, right, and you're trying to do it from a looking for investment, so you're going to sell equity in the company in exchange for cash to run the company, it can be a valuation change of the people that look at buying that equity, say, okay, there's intellectual property here. We have an ability to compete and to exclude others, maybe to develop our brand awareness. And so it can be a value when you're comparing two businesses they could buy equity in. The one that has intellectual property may be able to get more money than the ones that don't, right? If you're looking at purchases of companies, right? Anybody, of the business owners that are here, who can imagine someday they might sell their company? Anybody? Right. Tim over here can. If that you're looking at how do I want this to sell in the future, right? And the sooner you start thinking about that, the bigger you can make that number potentially be. Intellectual property, just as it's valued in the equity, when you're looking to sell a company and a buyer's looking to buy it, it can be part of the value transaction for, okay, if I want to buy this business, what kind of intellectual property, what ability to exclude people from using my branding, those kind of things, what has been done around it that will be value in there, that is things you can build into that purchase price. And while it might not be the whole drive, sometimes it is the whole driver, right? If you're super lucky, you could be Nokia's patent portfolio bought by Google for, a large amount of money. But if you're not, it might be the difference of you think, okay, I want to sell this business for 2 million versus I want to sell this business for $1 million, right? And that's a 50% difference that could be, even when you're talking a small business transaction for a sale and exit, can be a driver of that deal difference, right? And so the sooner you start working on things of thinking, what do I want this value to be out, the sooner you can build those things, and IP can do that for you. If you're thinking of going all the way to IPO, I don't know that there's less IPOs today than there have been historically in a long time, but that if that's where you're going, the initial public offering, right, selling stock on the stock exchanges, it turns out you usually have a higher IPO valuation when you've got intellectual property wrapped around the company that's going to sell. And so these are kind of some just large numbers on kind of what those difference can be. And relationship to different types of IP that we're going to talk about. And so as I said at the beginning, you don't have to do any of this, right? Remember, you don't have to even, if you don't want a trademark, you will not offend me. If, at the end of this, you're like, I absolutely don't need to do any of this. But if you do, this is the kind of relationship you're going to be in. If you're thinking very long-term for your business, not even very long-term, if you're thinking, what is your eventual path? And especially if you're looking at any of these like larger volume sale of the company, IPO, raising equity, or even raising debt, right? And it's an asset that a bank can give you a loan against and, take a security interest in. It becomes something that you can do without having to, you don't have to sell anything to anybody to transact. A lot of these, they're things that you can build in the business to build value without having to go buy another piece of equipment necessarily. So it's interesting in that sense. All right. Now we're going to get into the specific types. I'm going to start with trademarks. All right. When we're thinking trademarks, folks have probably seen this little TM sign or the R sign on things, right? Every time there's a commercial on TV, Coca-Cola's got it. If we look around the room, we look at all the soda cans, they're all, labeled up with trademarks. Those are trademarks. Trademarks are a registered form of intellectual property in the United States that at the federal level, we register with, easy to remember, the United States Patent and Trademark Office. Trademarks, what I want folks to take away from that is there's a lot. I'm gonna talk about 4, and we hit a slide that probably had 9 different pieces of IP. Trademarks can apply to pretty much every business in the world, every charity, right? And that's why I put it first, because it is the most likely that everything from, technically a kid's lemonade stand on the corner of all the way to a multinational corporation arguably can have a trademark, right? And so the question is, why is that? It's because and what do trademarks do? What I want folks to take away is trademarks apply to everybody as one, any business, and 2 is what do trademarks protect? Because that's when you'll help flag for you. Do I need a trademark? Is this something I want to register? when we think of trademarks, I have this happen with clients. I've done it myself a lot of times, right? You think of trademarks in relation to your brand. You're like, oh, that's my brand. And that is how it ends up playing out. But the legal right, what I want you all to take away from it is what is it's doing? Why has Congress protected this, right? They've protected because the whole point of trademarks is to prevent consumer confusion. So while it's your brand that we're putting the trade, that is getting registered and it's trademarked, the whole purpose of the setup is so that if I go to buy something, I'm not confused as to who made it, right? And so when you're thinking of with having that in the back of your mind about trademarks, you can ask yourself, is this cool branding that I've done here, is it unique to me so people can identify me? And if you can, that's the level to get into the trademark office, right? You don't have to have sold anything yet to go actually file your application. There's a whole bunch of weeds we are not getting into on this introduction to IP about how the trademark registration process goes. But in general, if you're selling something or you're going to sell something, and that attribute of it is something that you think consumers will be able to identify and distinguish you from somebody else in the market for that good or service, that's when the light bulb can go off. I want to prevent people from being confused about me. This might be a trademark. And so that's it, that public confusion. And why that helps you, and I've seen doing this for years, is everybody gets mad, right? Like, if we look around the room, we can probably find some things, right? Like you find, oh, that's a picture of a harbor, a harbor town there in a circle, right? And you're selling a set of wine or something that's got harbor town in a circle. You're like, oh, the BDC is using my mark, right? Well, no one's confused at seeing that and the wine bottle, right? To use a very simple example, like they don't think that the BDC is here with their sign selling wine. There's no customer confusion. And so while it might tick you off as a business owner that two things are very similar, right? It's not the kind of thing that I would advise you to go file a lawsuit about when there's zero chance of the customer overlap and the confusion, right? And it gets hard because McDonald's is so ubiquitous that people will try to use the golden arches to sell their dental practices, and that is a true case, right? And when you reach absolute fame, call me and we'll have another discussion about how to protect famous marks. But most marks are not famous to that level, and so the fact that there is two things that are not appealing to the same customer in the same customer transaction is not it's frustrating, especially if it's like you're, someone else on Main Street in the same town you're at is using the same kind of logo. But if there's not a chance of confusion, it's okay, right? The law is not protecting because the law is not looking out for your brand. The law is looking out for consumer confusion. It's an old right. Oh, go ahead.
Sorry.
Yeah.
Can this be applied to recipes? For example, my aunt has like these nuts that are very cheap. It's the time and effort, and it's a very specific recipe. But other people in the area have tried to recreate it.
Yep.
And I'm trying to get her to really set her mark on that. So can that be applied?
So yes and no. Okay. So you have to think about what does a consumer recognize out of your aunt's or grandmother. I'm sorry, I forget.
My aunt.
The aunt's recipe, right? So they recognize arguably the taste, right, is distinct, and that's what people are trying to copy. So turns out you can actually get a trademark on taste in the United States. It is almost unadvised in the literature, although it exists, because the idea of proving that a customer was confused by the taste after a sale is an interesting legal battle. I don't want to represent you in front of 12 random folks off the street, but you are allowed to do it, right? And that's what makes me maybe a little different of attorney is I'll be like, look, how do we actually win on this one? Now, if you want the PR thing of like, hey, we have the taste, trademark for this recipe, it could be good branding with no joy of enforcement, which is a whole different business question. But that would be the outcome of that recipe would be the taste of it. Totally protectable. If there's any description of it, right, of like, hey, we sell these with this, hey, this is my aunt's recipe, then that's trademarkable because that's what somebody might see and distinguish. But the recipe itself is not. We'll get to two places where recipes potentially could be, right, which will come up in copyrights on if there's some publication of the recipe and how it's written down. And the second one is trade secrets. And the famous recipe for trade secrets there is the formula for Coca-Cola. And so there are ways to protect it. And, the question then becomes, who are you protecting it from potentially? But those are things those are the two kind of the four pillars of major intellectual property. Trade secrets and copyrights is where we get. So I'll use that as an example when we get to those in a second. Does that help answer?
Yeah,
Okay. You had another question in the back, or? Oh, that's fine. Yeah, I figured it was that, or you were telling me to get moving, right? Like make sure I'm on time. So you're good. The trademarks are old. 13th century England is where our kind of current thinking about the existence of them comes. Same purpose always has been to protect against customer confusion. And they arguably go back a lot longer than that, but the current sort of like understanding of them. As you said here, colors, scents, you can do tastes, although that one's a hard to produce. Scents is also a hard one. And I've talked about the PTO. We've kind of hit these like things I want you kind of, if I put this whole slide together, let's start at the bottom. How do I know from as a business owner whether it's a trademark is something I might want to register? And they're fairly easy to do. You can find services for a few $100s on the internet that'll help you, that'll no problem. They'll help you get it registered. They'll get it filed at the Patent and Trademark Office. So the question is, hey, if I use the lowest, like most of them will give away for $500, right? Is this worth my $500? Is the question you're asking yourself. The first one would be from my end is, do you have any marketing or branding spend yet? If you don't have any of that, right? You haven't come up with packaging for the recipe. You haven't bought an ad somewhere. You haven't done anything. Doesn't mean it won't be something that you want to do in the future, but probably today is not the day to spend that $500. Spend it on something else until you've gotten there, right? And then if you have made that spend, the other question is, how important is it in my business, right? If somebody copied this, could I change it, right? If it's if I've only taken out one ad in the local paper and it runs every week and I can update that ad pretty easily, I'm dating myself by probably imagining that, but let's imagine it's sitting on, it's an eBay store. I could completely rip the thing down and put the thing back up in a day's time and change all the branding if I wanted to. Is it worth trademarking it at this point, or it's an Etsy store, those kind of things? It might feel like it is, and you might want to do, I'm not dissuading you from doing it, but you're not at that point of like where there's going to make economic return to have done it yet. But once you start getting some traction, you've made the sales you've done there, and you think $500 is, to try, these are the two questions, those answer, and this is what you need. You need a mark, right? That can be a word, it can be a design, it can be anything we've talked about. Words, written words, and pictures, designs are the most common. And then the goods and services. Well, hey, what am I selling? What's associated with that? What are people going to be confused when they're trying to buy? And then, I've got to use it or intend to use it. Before you fully get it registered, the patent office will make you show them that you have actually used it to sell something or attempt to sell something. So you can apply for it before you do that. Those are called intent to use marks. But eventually, you're going to need to actually try to make a sale with it. And that's it. Benefit of trademarks, you got to pay money periodically, but they can run forever. You can have the same trademark for hundreds of years, right? And they're created the moment you use it in commerce. So the first time you sell something, you have the potential to have a trademark. The question is, have you registered it yet? And that is that federal registration, although you can do it with states too. But I advise federal for the same basically price you're going to end up with getting the whole United States and its territories as constructive use. And so those are the questions you would ask. And what does it get you? It gets you de facto use against others. So if someone in Oregon is using that recipe of the same name, but you've registered and the patent office has granted you the registration, it's just like you used it in Oregon. If you don't register it, and they're using it in Oregon and you're using it here in South Carolina, you geographically are allowed to coexist. And so you can't send them a cease and desist letter saying, hey, stop selling this recipe in Oregon. Right? You could try, but there becomes a really messy debate as to whether there's common law rights. So if you think you're going to expand into other markets, that registration will protect you at where you're selling and will protect you around the United States. Any questions on trademarks? It's really high level. There's a lot more to it, but those are kind of the big things of where you think, should I go spend that $500 or should I call an attorney to talk about whether this is something to trademark? All right, the next one, patents. Patents come in three broad flavors, right? The utility patent, which is protecting a technical thing, right? If you think machinery, if you think software processes and the way they make computers work, if you think that's kind of that technical aspect. Design patents, which are protecting the look and feel of something, the ornamentation, and they come in plant patents. So if you have a non-sexually reproducing plant, you've hybrided something together. If that's your business or it comes up something, you can get that. That is a very niche thing, although there's a lot of money in it. If you have if you have a new strain of corn that you can reproduce based on this, or certain plants that'll flower in manners, there is money to be made in it, and you can protect it. They all go to the U.S. Patent and Trademark Office, similar to trademarks, different wing of it. And they operate a little differently, but your most common ones are utility patents, by and far and away the most common, and then design patents for the actual look. A lot of companies that have a lot of patents, it turns out like Apple has a ton of patents, but a large portion of theirs is actually on the consumer experience and is for the design of the hardware that they're selling, not the technical features in the back end, although they do have some of it. You have other companies like most of your cell phone manufacturers like Samsung doesn't, just to use the counterpoint, they're competing directly with each other. Samsung is actually making its own chips and doing things, so they have a lot of hardware and interaction on the utility side, and that's the easiest example I can use because everyone's carrying one in their pocket or holding one on their desk. And so those are the two kind of different worlds. If it's how something works or how it's made, think utility patent. If it's how it looks, think design patent. So what are we protecting with a patent, right? We're protecting, even whether it's plants, designs, or utility, we're protecting something new, an exclusive right to an inventor, and that's one that is starting to come up. Who can get a patent, right? AI cannot get a patent in any place on the planet right this second. There's some countries outside the United States that started to entertain it, but right now we need a human being, at least one, to come up with something that is new, and that is that inventive aspect of it. There's other requirements to it, but that is the big one. So if you have a technical thing, a design, or a new plant that a human being in you or in your business, one of your employees has come up with, utility patents, design patents, or plant patents might be something you think. Pretty old, not as old as trademarks from a legal regime, dates back to the 15th century, although there's some literature that says, ancient Greece. So again, why are these the four major ones? Because they've been around for a long time. If we use an example thing, we're not going to talk about data rights. The ability to have that, data compilations and having people have pools of data is pretty new in relation to human history. And so that's it. And then it's an examination system. So the difference is maybe minor, and you'll see this in other slides. But if we think of trademarks, same office, going to the Patent and Trademark Office, trademarks are a registration system, which means if you can show you used it and you show it's unique, arguably to the world it feels like it's examination, but they're not really testing whether there's any actual consumer confusion, right? The right that they're protecting, the government is not seeing whether somebody would really be confused. They're just looking for like, hey, if I try to register Coke for soft drinks, right, in that class, they'll be like, look, somebody will be confused. That's dead obvious. And so they're registering it with a minor check, as opposed to examination for a patent where they have a core of patent examiners way bigger than the number of trademark examiners. Its job is to protect the public from registering a piece of intellectual property that's not new and that wasn't invented by the person that said they invented it. And so that's an examination system where you're going to have to go back and forth with that patent examiner and actually work to get them to take the default setting, which is, no, this is not new, thanks for telling us about it, and turn it into, yes, this is new, I agree with you, here's your patent. And so most of the things, trademark, or we'll get to trade secrets, no examination, that's completely, you do it yourself. But copyrights are a registration system, trademarks are a registration system. You don't have a high hurdle to get over. Patents have a high hurdle that you've got to get over, because the Congress has designated the patent office, make sure that people don't have that all the inventions are new. Whether they do a good job at that every day can be a debate. You get 5 patent attorneys in here, you'll get 10 different answers on whether that's a good job or not, but that's what they do. Key ideas to think of: subject matter eligible. I kind of touched on three broad areas, right? Is it a technical feature? Is it a design? Is it a plant? Inside that technical and inside the design aspect, and even inside the plants, there's some narrower categories. And so if you have something that's new, I would advise you to check with somebody before they will take your money. Right? Think of it this way: it's like a tax. The patent office will take your money for you to file something that's not subject matter eligible. So it's very much, if you think it applies to you, worth checking with somebody to see, are there subcategories that I actually fall into correctly that are excluded. The United States doesn't have as many, but if you're looking for overseas, like there are other countries where, hey, you have patent on, we don't do medical patents, we don't do, other countries, we don't do medical devices, and it's a a legal approach they have that is excluding those, and so it's worth checking. Your rights on this one only exist once the patent is granted. You don't have the right to exclude anybody before the federal government says, yes, here's your patent, and it's issued and it's all done. As opposed to trademarks, where I said, that you could sue that person in Oregon. There are some rights you have in things before you've gotten the registration that you could try to assert. Patents, you have nothing until the patent office has granted it. Thing. What does a federal grant get you? Same thing as trademarks: access to federal court. You get an interesting thing here, which you get in trademarks, but I didn't mention on that slide, is access to the International Trade Commission. So you have the ability to exclude importers. If someone is importing a infringing device, or if they're using your trademark for importation, and you've registered that with Customs and Border Protection, you have the ability to go and try to get that excluded. And it's actually, surprisingly, it is a court that is fairly cheap to enter, although you need the attorneys to help you get there, so they're expensive in that sense. But the federal government will do your enforcement for you. If you win your case at the ITC, the International Trade Commission, they will have customs impound goods on your behalf that infringe. And so that's a nice thing. It's hard to get, but it is something that can be a remedy, especially if you think you're going to get inbound competition from overseas markets. And so, what do you need to know? How do you know if you need it? This one, I think, it probably lends itself a little more. If you're paying folks in your business, or you are doing yourself through sweat equity engineering, right? Creation, if you're doing, whether that's software engineering, actual engineering of physical goods, or you're doing design, right? If you employ an industrial designer, or you've done things, right? Or you're, that creation, and clearly if you're employing botanists, consider plant patents. But that's the kind of thing. If you're spending money on that in your business, that's a flag to me right away. You should consider, is there a way to get value out of that spend in addition to what the transaction that they're doing for you? And then, does that spend give you a technical advantage over your competitors? And if you put those two together, hey, I'm spending on an industrial designer as an example, and I believe that the look of whatever I'm selling is giving me an advantage because customers are picking it off the shelf for it. Let's see if it makes any sense to get, wrap that with something that you can assert, because that's the way to, that's the way I think of, is this something to have? So that's patents in a very quick nutshell. Anybody have any questions on that before we go? All right. Copyrights. Copyrights are an interesting one. I see folks taking notes. Arguably, you all have just created copyrighted material right here in the instant that you put pen to paper, right? So copyrights are protections for authors or creators, right, and sculptures and things that we use the fancy legal term vest the instant you create something, right? So that copyright comes into existence whether you register it or not. All your notes are all your notes. There's a whole lot of nuance on, like, was that material that, like that. But if somebody wanted to start photocopying your notepads here and trying to sell them, you would have the right to go say, hey, that's my notes in the way that I took those notes, and stop it, right? And that's all you need. What the federal registration gets for you for the low price, I think right now, like, you can go to the Copyright Office for like $96 is the current price of the basic registration, is the ability to go to federal court and stop that person. You have to have that first before you go to the courthouse. And so but you had the copyright, it is purely a system of registration. There is no check. They don't even check to see you hear about, if you pop up, depending on like what your MSN or Google, news will feed to you, right? You see two artists suing each other over their, music, the copyright, and they both have copyrights in the music that was filed, right? It's because the Copyright Office is not checking for originality in that process. That's part of what you fight about in court. But if you've got an original creative work, whatever term you want to use for it, committed to a fixed medium, whether that's writing, sound, sculpture, software, code, you have a copyrighted material, and you have the ability to, once you basically asked for the registration from the Copyright Office, to go sue somebody. Registration system, Copyright Office, right, is a different office I've mentioned here. That's actually run through the Library of Congress. It's pretty straightforward these days. It's all electronic. There's very few copyright examiners. They check for formalities, basically. Did you fill your forms out right? Did you pay them the money that you were supposed to pay them? And if the answer is yes, you get a copyright notice. Pretty straightforward. It varies all the time, but even if you need it in a rush, like you want to go sue somebody, you can pay the rush fee and get that, within a few weeks instead of a few months. And so this one's the newest of the group, comes basically from the ubiquity of the printing press, right? Like, it was so hard to copy things by hand to make sculptures before the printing press came along, and before, mass production came along for things, that it wasn't really something you needed to protect, because that book that you copied, yeah, fine, take 2 generations to go copy it. But in the modern world, it's stuff that happens all the time. You see it from content in presentations all the way to that, to writings and things like that, but it applies to everything. This is one of my favorites as far as like people leave on the table, in my opinion, and I'll use the Etsy store again, or eBay, right? Copyrights, you can't copyright everything, but one of the things that people don't think of is all those pictures you're taking with your phone. You're fixing something in a tangible media, right? And so you think of, if you've got a retail store and you're going to post pictures of things, right? Those are all copyrightable, right? And copyright gets you some interesting protections that apply to especially smaller businesses that you don't think of, right? So they get copyright takedown notices. I don't know if anybody's ever, your kids have ever posted something on YouTube and then, it's disappeared because they wasn't theirs. It was, something else. But that applies to small, so on social media and or on, e-commerce platforms, the ability to have, literally, most knockoff artists are not going to do the work to make their own picture of your goods. They're going to take yours off your website and put it up right as it is. And so if you have taken, even just for that low price of $100, taken your 3 best sellers and copyrighted the images, you have a thing that most people don't think of as a way to say, hey, you're infringing my copyright by using the image in trying to sell this on eBay. And in my experience, eBay and Amazon and Alibaba, everybody will drop that like a bad habit, because the copyright is per infringement. And so that's one that you actually might have, because you fix something in a tangible way that you're selling on your store, that most people don't think of and they don't want to go do, but you could do it. And it's a great way to say, here's my copyright registration, please take this down. And you'll see it if you ever go to their forums. Almost all of them ask you to just type in the number of what you've got on the rights holder for this. They can check it, and they will make the other person prove that they have right to use it, because they'd rather not be accused of assisting somebody in copyright infringement. What does it get you? The same things as the others. Access to federal court, right? Which I'll get to on a slide here in a minute. One of the drawbacks to IP, although it is where it gets its value, is you potentially are always buying a lawsuit. But that's copyrights. Any questions on those? And those can run a long time. As long as the Disney company keeps making money off Mickey Mouse, these will keep getting longer and longer, is the kind of joke. But we're talking your life plus 70 years if you're the author, and for works for hire, which is things done for employees, 95 years from publication, or 120 years from creation right now. And so it's a long, long time. The last one we're going to talk about, trade secrets, kind of a mix of what's going on in the patents, can be a little bit of the trademarks, and even a little bit of the copyrights. Trade secrets are information that you get economic value from by not having be generally known to the public. And so that can be everything from the formula for Coke we talked about, or the recipes of your aunt, all the way to things of like your customer lists and even the processes by which your employees do things, like the know-how for, hey, this is how we interact and we do our sales calls, or this is how we do the, how we identify whether someone's a good prospect for us to go talk to on a sales call. All those things can be trade secrets. There's no registration system for them. It is purely just an access to go to court. If you've had trade secrets, gets weird because if it's all within a state, you're dealing with a state law claim generally, although there is a federal trade secrets law now. But so if somebody in South Carolina, one of your employees steals your trade secret and wants to go compete with you, you are looking at most likely dealing with a South Carolina state matter instead of dealing with a federal matter. If that employee takes it and goes sets up a store in Georgia, now you're dealing with potentially a federal matter unless you want to sue them in Georgia on it. And so it gets a little nuance in the way that you interact, that the federal rights don't necessarily, because they apply the same whether you're in South Carolina or whether you're in Georgia. But no registration system. The trick on this one is it's things that you get economic value from not being publicly known, with the requirement that you actually did something to keep it from being publicly known, right? And that's the trip that most people have, is like, hey, my customer list is super, super important. Did you ever tell anybody that worked for you that it was super important and they couldn't take it home? No. Okay, well, that's going to be a tough one.
If you sign a confidentiality agreement with a company, is that protecting their trade secrets?
That's the start. I'd say kind of the base level for if you've got enough processes together that you have an HR confidentiality requirement, right? The trick there is the company's duty is to tell you what that confidential information is. And while a lawyer defending a company like me will be like, look, all our information was confidential, right? Like the real answer is if you don't treat something in your business as confidential as opposed to something else, it can't, usually it's not going to be I covered everything. A lot of times for those employee confidentiality arguments, it's the start of a bad faith argument, which is like, Tim, this guy used to work for you, took all the stuff, downloaded on a flash drive and bounced. And the exhibit 1 is, here's his confidentiality agreement that says that. And exhibit 2 is like, look, we told him that like everything that's in this folder on the drive is confidential, and it had it in the name of the title, and he still downloaded it and quit, right? And so by itself, that doesn't make the things. Now, you can do it where you have the employees agree, like, hey, before we come into this room, sort of like an NDA between you and your employees, everybody understand Tim's presentation today is going to be all trade secrets. Everybody signed that Tim told you it was trade secrets, and I'm going to keep that paper, and we better not hear about this anywhere else. That sort of agreement for that point situation could be it. That's a level of like international chemical company approach to trade secrets that most people, I wouldn't advise you to try to build that from, unless you find yourself running an international chemical company. But it's a good hygiene, right? So if you're downloading stuff off the internet as a way to get started, totally works. And you want some confidential information clause in there, keep it. Totally going to work for your stuff, for your employees. And then as you get those employees, if there is something, the way I like to advise clients is if there's something that because your number one loss of trade secrets is not, as much as you might think it's like foreign act or theft from your business, that is not your number one, vector for losing something important to your business. It's your former employees, right? And sometimes it's even good faith. They think, hey, I got moved, like here in this area, my wife was working MCS Beaufort. She got transferred to here. We had a great thing going. I took your sales list and went there. That's your number one pathway. You may not want that to happen. And so as you as business owners or operators, what is the thing I would be really mad if somebody started using and they weren't working for me on the payroll? And if whatever that is, mark that confidential and then make sure that folks have your agreement and know what to do. And so we've kind of hit the how you have it. Building value, as we come in here in these last few minutes, building value for intellectual property, right? And kind of hit as we've gone on ways you can identify, and we'll get to here in a second. But how do you get the value out of it, right? When someone's looking at, they're going to buy your company, what can I do with this IP? When you're looking at the IP and you're going to the bank and they're thinking, hey, should I count this as an asset with which I use to loan money against? What are they looking at? They're looking at two kind of broad categories. The first is lawsuits, right? And every business owner in the world that's not crazy would be like, I don't want a lawsuit. And that is correct. You do not want to buy a lawsuit, right? But you might be in a lawsuit. And so there's offensive lawsuits, right? Where we're thinking of somebody stole something from an employee, left. And so that gives you that option. But there's also defensive, right? And very rarely in a business relationship do you just get a cease and desist letter out of the blue. It does happen. But much more likely, it's going to be somebody you're interacting with. Either you tried to sell to them or they tried to sell to you. And there's going to be something broke down in the relationship. And there's usually going to be, not everybody was perfectly, nice on both ends of that transaction all the time. Sometimes it is, but there's a defensive aspect to it too. So probably, not always guaranteed, there's going to be some ability to cross suit, right? So they say you've infringed my trademarks, and you're like, well, you've infringed mine too, right? Because we're both competing with each other and using the same sort of stuff. And that raises their costs. They originally went to their first lawyer and were like, look, we're going to sue these guys. And he's like, great, I had the complaint drafted before I even got off the phone with you. Let's sue them. And then they have to go find their second lawyer because now they're like, oh, well, I have the countersuit that said, I also infringed it. And we never talked about that. Now I'm in deep water, right? And so that's the sort of defensive nature of it, which you don't get if you don't register your IP as well, because the time frame also is bad. If you think about even the Copyright Office with their quick, few week registration, if you've just been sued and then you want to go register your copyrights because you think they took your software even though they said you use their trademarks, it doesn't work out. And a copyright's one where it's easy. You can't, until you've actually used the copyright and registered it, right? You can't sue. So now you're waiting for the Copyright Office to give you the ability to go back and countersue these people. And you're saying, I will get this copyright on my software that you stole from me. Wouldn't you rather have that in the bag if that's a risk to you? And so that's how lawsuits make the value, right? Is there the ability to sue on it? And if you've ever been through a diligence, that's the kind of stuff that when people are looking to analyze, is this an asset? That's what they're trying to find out. So if you've ever gone to apply for something with intellectual property, or you ever do, they'll ask you, hey, prove to me that you own this IP. Why? Because you have to be the owner of the IP to bring suit in federal court. Prove to me that the IP is still in force, right? That you paid all your fees on it, those kind of things. That's what they're checking. The other area is, which is not a lawsuit, right? Which could happen, but the thing where I like to live more of like, how do you get the competitive advantage, right? How does intellectual property help you win? And it helps you win in one, it gives you something you can license. So if you build value, whether you're going to go into like you may never have thought of like franchising, and it doesn't have to get to that level of licensing, but what the value you see in it, maybe you use that example of Oregon. You'd like the person in Oregon to be selling your aunt's recipe, over there. Now you've got something that you can define, hey, here's the contract, here's what you owe me. You owe me a penny per sale or something, right? It creates a revenue stream for you. If you don't have it registered, it's not that you can't have a license for IP that's not registered, but man, is it a lot easier to define in a contract of a transaction of like what you're actually paying for, what the other person's paying you for, and it gives you something to do. It also gives you that ability to have that option right away when a licensing opportunity pops up rather than having to go create it. The second one is increased competitor costs. Anybody who's trying to do their own analysis of can I sell in that market too, or we kind of used it here of like people stealing your pictures to sell things, is going to want to check your IP, right? Or check to see if someone's out there. So you raise the cost to your competitors by having your IP registered, and they go, oh, I don't want to get in that business unit, or hey, we need to talk to them more. And the last one's signaling, right? If you've got trademarks, if you've got copyrights, you look bigger perhaps even than you are, and people see that, hey, they're taking this seriously. And it's maybe a little bit of that increase your competitor, friction, but it's the value that you can get out of it. All right, last one with, I think if I'm following the time right, I have 4 minutes, which is probably not as long as you would want me to have on this slide, but is enough. So how do I approach you? We've learned about 4 areas of IP. What's Tim's approach to how do we find out if you have IP in your business? What can you take away from here? If you remember, nothing, or if you want to go back to the thing like where I find it comfortable and people call me, is the first place I want businesses to start is, let's start working at your differentiators in your business, right? And maybe that sounds like, if any of you have ever sat through kind of marketing training or thought about that, right? It's the same place the marketing goes. Start with your differentiators. until you can come up with what is your differentiator in your business might function just fine, right? Because sometimes there's not a lot of differentiators between two businesses. You're just the one serving that need in that market. But once you found it, that's what you want to look for. First pass, do I have a differentiator? Once I identify a differentiator, how does that help me win, right? Is that differentiator enough? If it's just like, it could be, hey, I'm the nicest lawyer anybody's ever met, right? And that's my differentiator. How does it help me win? Well, clients like working with me, okay? And we're following through. I need to assign a value to that differentiator. Why? Because IP is not free. Even if you don't pay a lawyer and you do it all DIY yourself, you're going to have to pay somebody somewhere in that system the filing fees, right? You're going to have to go to court. You can do it yourself, but there's going to be a monetary transaction. So, hey, how valuable is it to me that I'm the nicest lawyer, right? That people pick me. And then, okay, it's super value. That's how I compete. For the wins with high value, right? If I have multiple differentiators, what IP could protect it? In this scenario, being the nicest lawyer in town by itself, not gonna something that we have not discussed nicety as a protectable characteristic. Now, if I'm branding myself that way, if I've got a process, I've got a set of software that I wrote that shows you how nice I am. Those are the kind of things we want to think about. But that's it, right? So have we gotten to anything legal until here? No, not in the middle, right? And that's where I say I like to live at what actually has value to your business, because these are 3 questions you as business owners I'll help you walk through them, but like they're the questions you all should be able to answer for yourself. Once you've done that, then you can think, okay, what IP could help me protect this right to win, this competitive advantage, this differentiator? And then I want to build that into my business plan. How much does it cost? What do I have to do to maintain it? What do I have to do to register it? How do I have to interact with my employees from agreements and things? And then once I've got that, I can take action. And this is where attorneys can help you kind of in all of it. But in this world here is where you start to get into legal professionals, because there is nuance, right? If we deal with recipes, what part of the recipe am I protecting? What can I do? But you all as business owners, business operators, can bring the first 4 kind of fuzzy interaction there. But if you follow this pathway, seems not super simple, it's 6 areas. But if you do that, I find everybody will be happy at the end, whether you use the IP or not. People are like, hey, I know why I did that. I know what it's for. I know why I made the spend and what the value is to me. And that story you can tell yourself and be happy with, but it's also the story that then lines up with when you're looking to build that value and how to use it later. And so this is how Longship Legal approaches IP. And this is what I advise you all, keep this slide and look at it of like, hey, do I have something? If you follow through that, you'll answer your own question of, is it worth the value of what I want to spend on? So any questions on that kind of walkthrough? I'm going the wrong way. And so that's my presentation, my lunch and learn. I hope everybody learned something. And I think we're coming right up at the 1 o'clock time. I'll take any questions. I'll definitely be here after, which doesn't help the folks on the live stream. I apologize. But, for folks here in person, I'm glad to hang around and answer questions. So thank you.
Nice to have you.
Thank you.